We don't know what the charges are exactly, but we know there's 34 allegations of false reporting, non-disclosure agreement. And so they pay Michael Cohen, who's the lawyer, and they put it under the legal expense category. And that's being disputed. Well, there is no other expense category for what took place. Michael Cohen's testifying, well, most of this went on, I was not his personal lawyer. Well, isn't that convenient? When did that happen? What were you? It's Mr. Fix-It. Mr. Fix-It, how come your stationery talks about you being a lawyer for Trump? First, I want you to listen to this, and then I'm going to do what I want to do. Go.
This morning, signs Donald Trump's criminal trial is coming to a close after his defense team took a sprawling first crack at Michael Cohen. Mr. Trump's lead attorney offering jurors a grab bag of reasons to question Cohen's motives, from money, fame, and media attention to jealousy and a lighter prison sentence, all in an attempt to argue Cohen, the only witness who directly ties the former president to the prosecution's charges, can't be trusted.
Can you believe I've been in here for 5 weeks instead of campaigning?
Trump attorney Todd Blanche first launching into Cohen's videos on TikTok that had criticized Blanche, but the judge quickly warning, don't make it about yourself. Cohen depicted as a jilted former fixer now out for revenge. Blanche asserting, you were actually obsessed with President Trump, weren't you? Citing Cohen's own words in his book. Cohen also admitting he made more than $3 million off his books. Tuesday's cross-examination, highly anticipated, but only a small portion was spent on Cohen's criminal history and admitted lies under oath, and nothing on the critical testimony Cohen had provided just hours before.
Whoa. This is the first day where they're doing cross-examination, and nothing on the critical testimony. They'll get to that. And critical testimony for what? Look, let's play, shall we? If every damn thing Michael Cohen says is true, it doesn't matter. As I pointed out months and months ago, non-disclosure agreements are legal. Non-disclosure agreements do not violate federal campaign laws. You are allowed, if everything Michael Cohen says is true, you are allowed to enter into a contract, a non-disclosure agreement, for money. Most people who leave jobs or who are fired from jobs are required to file or sign a non-disclosure agreement in exchange for something. Sometimes they'll get a severance payment or a bonus or whatever it is, health care. It happens a lot, a whole lot. Members of Congress have done it. Reporters for every major news platform have done it. Every major news platform has done it. And I dare say that every lawyer from every law firm in that courtroom, those law firms have done it. That's number one. Number two, how is it an illegal campaign contribution? Well, Mark, let me explain. No, you don't have to explain. The FEC looked and they said no. The U.S. Attorney's Office in the Southern District of New York looked and they said no. The prior DA said no. This DA said no until he said yes. So you don't have to listen to me. We don't know what the charges are exactly, but we know there's 34 allegations of false reporting. Non-disclosure agreement. And so they pay Michael Cohen, who's the lawyer, and they put it under the legal expense category. And that's being disputed. Well, there is no other expense category for what took place. Michael Cohen's testifying, well, most of this went on, I was not his personal lawyer. Well, isn't that convenient? When did that happen? What were you? It's Mr. Fix-It. Mr. Fix-It, how come your stationery talks about you being a lawyer for Trump? Meanwhile, Donald Trump is being manipulated throughout the whole process. This is the guy telling him what checks to sign. This is the guy telling him to set up an LLC. This is the guy bringing him the invoices. And somehow Donald Trump, relying on his lawyer, Donald Trump. Now let's figure this out. He wanted to get around the disclosure requirements. So what did they do? He put it under legal. Well, that doesn't get around to disclosure requirements. Oh, come on now. They reported it on their books. Okay. But what about that federal campaign law? Since when does a state court with a DA have jurisdiction over a federal matter? When those who do have jurisdiction, by the way, as a footnote, as I said there is no issue. So how do you raise that? Well, they haven't. They haven't figured out how to do that yet. Oh, okay. So you're on trial for your freedom, and you're not exactly sure what it is you're accused of. Very critical testimony. Now, if you're in law school, say, for the first 5 minutes, and you're given a question based on Michael Cohen's past, his record, who's been convicted of so many perjurious felonies that you can't even keep track of them. Every agency he's dealt with, he's lied to. He's lied to his banks. He's lied to the IRS. He cheated on his taxes. He's lied to the FBI. Lied to a federal judge. Just question. Law school newbies, is that a good witness? Reliable? No. Question law school newbies, if you're a prosecutor and your case is built around this individual, is it a good case? No. No. So now you know the whole thing, but you don't know this. I talked about this on radio too, but I want to elaborate here. I'm a Supreme Court justice, and I'm on the fence on this issue of immunity. I just heard Biden, Garland, Jack Smith's lawyer, his counsel in front of the Supreme Court, and one of the main things he says is, look, Donald Trump, no president has immunity after they leave office. Official acts or no official acts. No immunity? No, none. How can that be? One of the more thoughtful justices says, wait a minute. So you're going to put trust in the prosecutor that they'll make the right decision about whether to charge or not? And the lawyer for Biden, Garland, Smith says, we have to trust our prosecutors. We trust them every day. It's called the public trust. They have to balance the issues and make these decisions. And then he says, what's in it for the prosecutor to lie? They have no reason to lie. Prosecutors lie all the time, or they fudge, or they withhold, or they emphasize, or they do all kinds of things, depending on who the prosecutor is. Why would it be assumed that individuals with such enormous power to destroy individuals, other individuals, are all saints? The system isn't built that way. The whole justice system is built to protect the defendant, not the prosecutor. I'm a justice, and I'm on the fence, and I'm watching what's going on here. Now, if you're really sharp, you're going to say, Mark, what does this case have to do with Trump as president, and then whether or not any of his immunities carry over for when he's not president, since this has nothing to do with that, it has everything to do with it. You'd be right on that point. But here's where you'd be wrong. This is just one example of what happens when prosecutors are out of control, and one example of what could happen if the door is thrown open, where a president, now a private citizen, is subject to criminal investigations, not just by the feds, but by local authorities, DAs. There are thousands of DAs and assistant DAs. Thousands. The Supreme Court's going to give its imprimatur, its rubber stamp of approval, that you can, in fact, sue an ex-president for a multitude of reasons. For actions he took, I would argue, public or private. This seems to be the view. When he was president, this is what's going to happen. the door can't be barred anymore. Can it, Katie? No. What a disaster. And in this case, we have a former president who's running for the presidency. And he's got a gag order. And he's got a 34-count indictment. A 34-count indictment that doesn't even mention the federal statute which theoretically saves the 34 counts of these state charges, where witness notice wasn't even given to the defense until 24 hours before, if that, so they couldn't prepare. And how do you have a due process defense if you're not even sure what you're defending against? That's why so many of these legal analysts are throwing their hands up. But that's why Mark takes it to the next step, steps back and says, okay, I hear all this stuff. They're right. I know they're right because I said it before most of them. Collateral evidence and so forth, but that's not the point. If you're a Supreme Court justice, this should absolutely affect how you look at this immunity case. And you should do, number one, make the case that this case should not have been criminalized involving the election in January 6th, particularly when you look at the statutes that have been used to go after Trump. The Klan Act of 1871, the Enron Obstruction Act, and the Federal Contractor Abuse Act. You're way out of your statute realm there. You're creating a fact pattern to trying to fit in the statutes that are not applicable. And this court should say this is effectively the Manhattan case. Oh, for different reasons and in a different way. But we have another prosecutor who's taken statutes, who's twisted them, who's trying to push the fact pattern into the statutes, just as we have in Manhattan. A prosecutor with a judge who's concocted allegations that are complete fictions. And we don't have to surmise, as the Biden, Garland, Smith lawyer said to the court, that prosecutors behave themselves. We have the cases against Donald Trump where prosecutors not only don't behave themselves, they are way, way out of control.
Want to see more Mark Levin? Go to levintv.com and subscribe now.